Cathaoirleach, I welcome the Trade Union Recognition Bill 2021 and strongly support it, and I compliment my colleagues and people before profit for bringing it forward. I believe that not only the right of workers to join a trade union, but also that their employers be obliged to recognise the union and to negotiate with the union on pay and conditions of its members. I've been a proud trade unionist all my working life. During school holidays, working in a meat factory as a member of the Irish Transport and General Workers Union, as a farm worker on Bulmer's Apple Farm, I was a member of the Federation of Rural Workers, and as an employee of a local tannery, I was a member of the Amalgamated Transport and General Workers Union. And from December 1971, when I started work as a clerical officer with Waterford County Council, I became a member of the Irish Local Government Officials Union, now FORSA, and served as a branch officer and activist for the next 30 years. I've served on the national executive of that union and as chairperson of its Health and Welfare Division when I worked with the South Eastern Health Board. I represented the union on Clonmel Trades and Labour Council and served as the council's president. Our family, Cathaoirleach, has a tradition of union membership and activism. My father, Jim Healy, was a founder of the Clonmel branch of the Irish Transport and General Workers Union in 1932, and his father before him, also Jim Healy, was a union member at the turn of the 20th century when he worked as a carter with Murphy's Brewery in Clonmel and Thurles. My maternal grandfather, Patsy Meany, was also a union member at the turn of the 20th century when he worked as a labourer with Clonmel Corporation Gas Company. My father-in-law was a branch officer with the Irish Union of Distributed Workers and Clerks and was condemned from the pulpit for leading a strike for better pay and conditions for members. As always, church authority standing with the employers. I strongly recommend union membership to all workers, and especially young workers, and especially at a time when casualisation, short-term and temporary employment is the order of the day. Unity is strength, and the trade union movement have won massive victories against all the odds. Many of them now we take for absolute granted. Won the 8-hour day. Previously, workers worked for 14 hours under desperate conditions. The five-day week, public holidays, annual leave, pension and sick pay schemes, and very many more. The trade union movement, I believe, should go back to its roots and remember the example of men and women of the 1913 lockout. And on this, the 109th anniversary of the Easter Rising, we should remember with pride the great trade unionist James Connolly, 1916 leader, executed 109 years ago last Monday in the Stonebreakers Yard in Kilmainham Jail by British Crown Forces, shot tied to a chair. Connolly's writings are as relevant today as ever. His book, Labour in Irish History, is a masterpiece and is well worth reading and should be on the curriculum for our Leaving Certificate students. Current Irish law entitles every worker to join a trade union, but there is no obligation on an employer to recognise and negotiate with the union. So it is at the whim of the employer to deal with the union or not. Trade union negotiated rates of pay and conditions are not only good for union members. Studies have shown that unionisation and trade union pay and conditions raise the wages and benefits of all workers. This, Cathaoirleach, is a common sense bill, it's a reasonable bill, and it's an important piece of legislation which I fully support. Thank you.
Thank you, Deputy Murphy.
Thanks, and thanks to all the colleagues and all the opposition parties who supported our bill. I would just point out that we're going to finish 10 minutes early, and the reason we're going to finish 10 minutes early is because the Lowry Group, who fought so hard to get their time to speak on these matters, don't presumably consider it important to come and speak about trade union rights, or maybe they're embarrassed because they're going to vote against trade union rights later on today. I'd agree with one thing, that the Minister in response said that the approach set out in this bill would undermine the voluntarist approach to industrial relations that has existed down through the decades. Correct. That's precisely the point of the bill, because the voluntarist system of industrial relations that has existed through the decades is one that has worked in the interest of employers, not in the interests of workers. The Minister in the first statement set out what he said was compelling reasons for the government's opposition to this bill. Effectively, there were two mentioned. One, the kind of suggestion that you often get in this place that it is unconstitutional, and secondly, the reference to how great the voluntarist system is. Just in relation to the suggestion that it's unconstitutional, I thought Deputies Lawler and Gibney actually addressed this point very well. This is a paper tiger that the government hides behind to avoid acting. There's no basis in terms of the relevant rulings to say that it would be unconstitutional. And compelling cases were made by Deputies Lawler and Gibney. But I want to add to that something that Minister Smith at the end spoke about the state being bound to uphold under international law and guaranteed a number of international instruments which the state has ratified. And I want to draw attention to the European Convention on Human Rights and a decision in Demir and Baykara versus Turkey in the European Court of Human Rights, which I think has enormous relevance here, whereby up until that case, the European Court of Human Rights had effectively held that the right of workers to bargain collectively did not constitute an inherent element of the freedom of association. So the European Court of Human Rights had a similar position to the government, which is that yes, you have the constitutional right, or the right protected under the European Convention, to join a trade union, but that does not imply that your employer is compelled to negotiate with you collectively. But that court decision changed things. A human right the court held, and I'm quoting here from a very important pamphlet from Darrell Dart, the human right the court held must be interpreted in a manner, quote, that renders the right practical and effective, not theoretical and illusory. Consequently, the court concluded that the right to bargain collectively with the employer had become an essential element of freedom of association. And a year later, Demir was cited in another unanimous decision of the European Court of Human Rights, upholding the right to union recognition and collective bargaining as integral to freedom of association. So the way that the government is suggesting the right to freedom of association is protected has now effectively been characterised by the European Court of Human Rights as theoretical and illusory, lacking in legal validity. There's also the point that there's already legislation which compels duties of consultation and recognition on employers. Universities Act 1997, the Education Act 1998, the Institute of Technology Act 2006, and the Railways Act of 1924 and 1933, which have not been challenged in terms of their constitutionality. So it's not true that this would be unconstitutional. Final couple of points is just this idea that the long-standing system of voluntarist system has served us well over the decades. I thought it was quite revealing that the Minister earlier said, I believe that a strong and well-functioning collective bargaining system, which we don't have by the way, supports productivity and fair wages, especially in low-paid sectors. I mean, the voluntarist model, whereby employers are able to say, okay, you've joined a union, you've all joined a union, but we don't have to deal with you, that works for the employers in low-paid sectors. It's part of the reason why we have, relative to other European countries, the highest rate of low pay. It's why we have such high rates of precarity, and it's why we have less rights than workers in other European countries. That is facilitated by the government's anti-union practice, which is clouded in the language of voluntarism. I also would say it's interesting that the government's language around the Adequate Minimum Wages Directive, where what's now said is there's no obligation on member states to reach any prescribed level of collective bargaining coverage within any defined time frame. So the government signs up to a directive which says you have to release an action plan to increase your collective bargaining coverage to 80%. By the way, the best way to do that clearly is by increasing union density and union membership. But then the government says, don't worry, we don't actually have to reach reach that by any defined time frame. So like, we're going to sign up to it, but we're going to sign up to it in the knowledge that we never actually have to do anything about it. It's quite revealing, and it reveals why the government has dragged its feet on it and continues to drag its feet on it.
Thank you, Deputy Murphy. That concludes all the speakers, and thanks to all the speakers that contributed to the debate, and to Minister Dillon and to Minister Smith. And the question is now that the bill be now read a second time. Deputies who are in favour say tá. Deputies who are against say níl. In my opinion, the question is lost. Votes all. The division will be postponed until the weekly division slot this evening. Thank you.